Okay, welcome everybody to our last session of the fall conference before we jump into juvenile this afternoon. We are pleased to have Reed Richards, who is a Deputy County Weaver Attorney, with us, as well as he brought a guest with him, Todd Utzinger from the Davis Legal Defenders. So as the agenda says, we're here to talk about the bias that we may or may not have against defense counsel and policies and procedures. So we will turn over to Reed and Todd. Thanks so much.
Thanks, Bob. That's an interesting topic, bias, and I don't know whether we're going to talk about a lot of bias, maybe a little bit. Mostly we're going to talk about how attorneys, defense attorneys and prosecutors ought to work together. Just a little bit, kind of in introducing myself, and then I'll do the same with Todd in a few minutes, but I've been at this business for quite a long time. In fact, an awful long time. When I started, I actually went to school in business and wanted to be a tax attorney, and went to Los Angeles and practiced tax law for several years. And then my wife decided she wanted it close to the family, so we moved back here. I fully intended in doing a business law type practice when I got back into the Ogden area where I'm from. But my father and one of my good friends from high school, John Kane, had taken on the public defender contract for Weber County. And so when I first got back, they were in the midst of a murder trial, and so I sat in on that trial and listened. And as I listened, I thought, you know, this is a whole lot more interesting than tax law. So I decided then that I'd delve a little bit into the criminal part. I still, as I was doing private practice, did a fair amount of business, but I did a lot of the criminal work, working as a public defender in Weber County for about 10 years. And that, I think, made a real impression on my life. One was the cases that we handled. The first case that I can remember that I was given, it was actually a case that Judge Gould, who was the presiding judge in the second district then, gave me. He called on the phone just shortly after I started practicing in Ogden and said, I've got a case of a girl that was in front of me today, and I'd like you to take it. And I said, fine. I brand new. I haven't really done any criminal cases, and I've never done a trial before. And he said, oh, that's all right. I think you can handle it. And I said, well, what kind of a case is it? And he said, well, it's a murder case. And I said, well, Judge, I don't know that I can handle a murder case. And he said, oh, I think you can. They had no rules on who could handle those kind of cases in those days. So he said that she was in the county jail and I ought to go over and talk to her. So I walked over to the county jail, which was then right on top of the municipal building, which was right in downtown Ogden. Actually, that municipal building was kind of handy. We had the police department, Ogden Police Department on the first floor. We had all of the district courts and circuit courts at the time in that building, and all of the county offices, including the county attorney in that building. And then on the very top three floors, Steve, you remember this, the top three floors were the county jail. So I went over and asked how to get to the county jail, and I was directed to an elevator that was out kind of behind the building. And that seemed kind of odd. Later I found out that the main elevator for the building also goes up there, but they don't let defendants and defense attorneys go up that. So there's a bias against defense attorneys. So I went around to the back to the elevator, and it was a pretty questionable elevator. In fact, I can see that the trip up to the jail might be more frightening than spending a day in the jail. That elevator would go up a few feet, and then it'd stop, and then it'd go down a little bit, and then it'd go up, and it took a good 5 or 10 minutes to get to the ninth floor where the jail was. But we happened along the top and finally got to the top. In fact, that jail was right on top of the county attorney's office. And so in later years, when I was county attorney, we had some situations where people were escaping from the jail. And I think it was built high enough that the thought was nobody's going to escape from a jail on the 9th floor, 9th, 10th, and 11th floor of this building. So it didn't put quite as much protection on the windows as maybe they should. So people, I can remember one particularly that was able to get the bars off, open the window, tied some sheets together, and was able to go down to several floors and kick in a window. Well, the window he kicked in was the county attorney's office. And when he got in, he realized he was in the office of Bill Daines, who some of you may remember, who had prosecuted him. and he did some really nasty things on Bill's desk. So we fixed the upper part of the jail so they couldn't do that anymore. But at any rate, I got to the jail, and I was directed to see this woman whose name was Margaret. And I remember walking to the door that she was in the little cell. She was in a holding cell waiting to talk to me. And I remember it was a metal door and had a little window at the top. And I remember looking in. And before I looked in, I thought, gee, this gal charged with murder, she probably is somebody that's going to look like somebody off a motorcycle gang. Big, rough gal with tattoos up and down her arms. But when I looked in that little window, I saw a woman about 24 years old, a nice-looking woman. She could have fit pretty well in a Sunday school class. She looked pretty much like a normal person, quite a nice-looking gal. But she was crying. So I walked in and I sat down and introduced myself, and she was expecting me. And I said, well, you're charged with murder. Why don't you tell me a little bit about what happened? And she told me a story that really has stuck with me ever since. She told me that she had married a fellow that had been her childhood sweetheart. A few months into the marriage, she realized that he had a really bad temper. And over time, that temper became more and more, and he became more possessive of her and of her time. He didn't want her to associate with her family or with her friends. He wanted all of her attention. He didn't want her to go out. Very much protective of his situation with her, and his temper would flare up every now and then, and he'd get a little bit violent. He'd yell and he'd scream. Eventually, it rose to the point where he actually started pushing her around. And it made enough noise that some of the neighbors called the police, and the police came over. And when they came, they knocked on the door. They asked about it, found that it was a domestic violence situation. They talked to him and then sent the fellow out, said, go walk around the belt block and cool off. That was kind of the police response at the time. And then when he came back, they talked a little more, told him not to do it, and off they went. This continued for over time, and for a time he'd be very nice to her, and then he'd become more and more violent. It progressed, and then, by the way, they had 2 children during the time that they were married. It got to the point where, in one of these violent episodes, he not only pushed her, but he started to hit her. And so then she called the police. They came and picked him up, took him to the jail. He bailed out and was back that same night. And, of course, they had a little confrontation again. Things then cooled off for a while. He was given a pretty good plea arrangement, and it was promised again not to cause any more trouble. Told her that, told the judge that. But over time, the episodes continued again, and she had to call the police again. They picked him up and took him to jail. This time he was there for a few days, and eventually when he got out, he stopped at the bar and then came home. By then he had worked into a real fervor. She could hear him come in the driveway. She could hear him yelling as he came up the steps into the house. So she ran upstairs and locked herself in the bathroom in the bedroom. He came in, realized she was there, broke down the bedroom door, broke into the bathroom. She was trying to go out the window, and so he helped her and pushed her out the window. It was on the 2nd floor. She fell off and broke one of her legs. He was then arrested and put into jail for a fairly lengthy period of time this time. But again, eventually he got out and came back. I said, well, why would you stay with her? And she said, well, what can I do? He's the father of my kids. He's the one that earns the money for the family. I have no way of supporting the kids. And so I was reluctant. And when he comes back, he always promises it won't happen again. So he came back again, or he was arrested for breaking her legs and pushing her out of the window, spent a significant time in jail. When he did return, the whole pattern started again. He got drunk one night, came back, threatened her and the kids, and then fell asleep on the couch. So she found the gun that they had upstairs and shot him in the head. Then she drug him downstairs and buried him in the basement. So that was the case. So it was pretty clear that she'd done what they claimed she did. She might have mitigating factors. But we talked about that case, and I worked it out with the prosecutors, and eventually we ended up her entering a plea to, I believe it was manslaughter case. She went to prison and spent about 3 weeks in prison and then was paroled. But that case kind of stuck in my mind, and we'll talk about some of the things that happened because of that later on. But my experience there as a defense attorney really had a big effect on me later on when I became a prosecutor and was in a position to make changes. And a lot of those changes were made and are still in place today because of the case that we talked about there. In the county I was in Weber County, we were able to get some of the police departments to try a concept of automatic arrest if there's a domestic violence case that causes injury. That was not a part of the state law at the time. And that worked well enough that eventually it became a state law. We worked with the domestic violence shelters to provide victim services. So a lot of things happen from things that you experience, and those may be, as it was with me, on the defense side. Also, when I worked as a defense attorney, I made some of my lifetime friends with the prosecutors. And really, I think, Todd, you'll probably talk about that as well, but that really is the way things ought to be. There's no reason why a defense attorney and a prosecutor have to be enemies. They are doing a job, you're doing a job, and when you go into court, you fight for your side of the case and get a result, but you can still be pretty good friends. Some of those prosecutors are people that have been lifelong friends. Bill Daines is one. He and I later on tried many significant cases together and became very, very good friends. Jim Davis, who later on went to the Court of Appeals, was a prosecutor at the time, and again, a wonderful friend. Dave Gladwell, who became a state senator and passed a lot of the legislation on domestic violence and other things, was one of the prosecutors. Ernie Jones, who is now a district court judge in Ogden, was one of the prosecutors. Chris Knowlton, who's kind of the queen of domestic violence. She retired a few years ago, but she was at the current county attorney's office, and then when I went to the AG's office, she followed me there and spent the rest of her career there and made significant changes in domestic violence. So those people become wonderful friends, and so the people that you meet today that are adversaries may very well turn out to be some of your best friends. So kind of keep that in mind in dealing with them, that you need to make sure that you don't destroy something that could be really helpful. I later on, after serving or acting as a public defender for about 10 years, went back and decided to run for county attorney and served 2 terms as the Weber County attorney, and then went to the AG's office and spent 8 years there as the chief deputy to Jan Graham. And during that time, I met Todd, and I'll talk about Todd in just a minute. The material that I've given you, we're not going to talk a lot about, but I thought it was important because it talks about your relationship with people on the other side, with the defense attorneys. And so you can kind of go through that on your own. There are, I think, 4 or 5 different items. There's a copy of 7717-4, which is the rules on treating kids with dignity as they're involved in the criminal justice system. And it also gives you the rules of how you deal with an interview that takes place in the children's justice centers, who those can be released to. Defense attorneys are one of the people that can receive copies of those on an appropriate request. But it also talks about when you can release to parents, when you can release to relatives, when you can release to outside parties. So that's one I think that you need to spend a little time in if you haven't read it closely recently. We also have in your material a copy of the new Privileged Communications Act, which was passed last year, which makes your victim advocates have a privilege to not disclose information given to them by victims. That's an interesting provision because obviously if they work for you as county attorneys or deputy county attorneys, they need to share some information with you. So there are some exceptions that allow that to happen. And there are also provisions that say that if they receive information that may be exculpatory and may be used by the defense, they have to disclose that to the county attorney, and it's up to you then to make a decision as to whether it does qualify for something that may have to be released to the defense. And if you think that it's a questionable item, then you go to the judge, and the judge actually will make that decision after the county attorney or deputy county attorney and the defense have a chance to present their view on whether it should or should not be allowed to be used. So what that means is that your victim advocates now are really part of your prosecution team, and you've got to pay attention to the things that are said to them and make a determination as to what has to be released and what shouldn't be released. The object of that legislation was not to indicate that victim advocates should release to anyone, to the prosecutor or to the defense or to the police. The idea was initially that anything said to a victim advocate ought to be confidential, just like disclosures made to a psychologist or a psychiatrist. But there have to be limitations if those people work in the public realm and work for a public attorney, and therefore those are kind of written into the provision. So take a look at that. There's also a rule of evidence that is attached to that outlines when it can be disclosed and when it shouldn't be disclosed. So those are things that you ought to kind of review together and make sure you have in the back of your mind. I've just listed Brady and Giglio. Those are the provisions that outline things that might be involving police officers that need to be disclosed to defense. I didn't include those policies, but because hopefully each of your offices has a policy. If you don't have a policy on that specific issue, you probably need to find one of the offices that does and duplicate that and make sure you've got that in place. That'll tell you what you have to make sure you disclose to the defense involving witnesses that you may be calling as a witness in your case, particularly police officers. And it's kind of up to you to do that because nobody else is going to do it. The last thing I left for you is the Lopez case, which is a recent Supreme Court decision relating to the victims' rights provisions and the release of, well, not the release of information, but the calling of witnesses at preliminary hearings. That's a really interesting case, and we'll probably get into that as Todd and I talk about some of the things that he's going to work with me on. So let me introduce Todd. Todd is an attorney that started out with us at the AG's office, did a great job there, decided to leave and take up a career as a defense attorney, and now he's the coordinator for the defense work, the public defender work that takes place in Davis County, which is a pretty sizable job. He's an upstanding guy and a great guy, and I think he'll be a wonderful addition. So I talked to him when I knew I was going to be doing this presentation and asked him if he would work with some of the defense attorneys and come up with some ideas of things that they might have that would help us work closer together in making sure that the case is prosecuted and defended properly. And so we're going to talk about some of those things. So Todd, why don't you come up and tell them a little about yourself, and then we'll go right into the survey questions.
Well, I appreciate the opportunity to speak to you today. When Reed reached out to me a week or so ago, it was a mission. Can you come up with some input from defense counsel, what they like and what they don't like, and the way we interact with as defenders with prosecutors. And I'm just going to jump in. Reed said enough about me. I don't need to talk about myself. Other than I will say, the time I was with Reed in the administration of Jan Graham's term as AG, 2 terms, was really a good time. I was 18 months as her spokesperson and communication director, along with Carol Klossma, Solicitor General. Reed was chief deputy, and Palmer DePalmas was chief of staff. And I often look back on that when I'm trying to figure out what to do, and I get kidded once in a while because I'll say, well, how would Reed handle this, or what would Palmer do? And good role models, and those of you who work with Reed are fortunate to have him in the position he's been so many different careers over the last several years. So that's Reed and my background, but we've always maintained some contact even when I went to the defense bar, and that was a switch. I'd been in criminal appeals for about 5 years and kind of learned the ropes. My wife, Barbara Berenson, retired a few years ago after being criminal chief for the U.S. Attorney's Office in Utah. So I know how to get along with prosecutors. I was married for one. I am still married to one. She's retired, but we're coming up on 28 years together. So I guess if she can tolerate me, hopefully the rest of you prosecutors can deal with me once in a while. So when Reed asked me the question...
Tell them the scope of what you do now.
I manage the legal defender program for Davis County. We have 15 attorneys and an appellate attorney and 4 investigators. I have my paralegal. So it's grown quite a bit since I took over to try to manage caseloads. But I think the most important thing we do is we interact daily with the prosecutors. And I think And I think this applies throughout Utah. I think on the whole, the defense bar and the prosecution bar, I like to think we have a good relationship. Obviously, there are some things that, in individual cases you can point to that didn't go the way you wanted. So when Reed asked me, I tried to kind of broaden it out to some sort of broad issues. And some are pretty obvious. Like one thing that defense attorneys appreciate are prompt, reasonable plea offers. Now, obviously, you know why we want reasonable, favorable plea offers, but timing also can be an issue. I can't tell you how many times I've had a client where, for whatever reason, it was slow in getting a plea offer, and then it comes and it's a good plea offer. Well, by then they've developed the attitude, well, if the case was so strong, they wouldn't be making such a good offer. So you have this boomerang effect, so timing can get to be kind of tricky. So if you got a defense attorney kind of pushing you, hey, I need an offer, it may be not that they're being impatient, it may well be that they're getting pressure from a client and they're worried that their client's going to go south if we don't get something on the table fairly soon. So that's why sometimes defense attorneys really push for a plea offer to get the case resolved while their client is willing to do something.
Let me make a comment on that. I remember back in my defense days, we always would every morning go over to the county jail and we'd interview all the people that had been arrested that needed public defenders. And then they'd do an arraignment after we'd done those interviews. And so we were looking at two things. We were looking at qualification, and pretty much if they're in the jail, they're going to qualify. And secondly, we're looking a little bit about the case. And I would guess a significant number of those cases, actually, we were able to resolve the same day they were arrested. Because the prosecutor had read all of the case reports. I had read the case reports and talked to the client, and there were cases that were simple and could be done quickly. So I think there's a lot of merit to looking at it, and if it's a case that is pretty clear, trying to resolve it quickly. I think everybody benefits. The victim benefits, if there is a victim, the system benefits, and I think the defendant benefits as well. So anyway, I agree with it.
And on that note, if there is a reason why it's taken some time to get an offer, it's often good to let us know, because then we can explain to our client, look, I've talked to the prosecutor, he's prepared to make an offer, but she needs to talk to the victim's family first. And they need to do that statutorily. So just be patient, because that can take some time. So just those little things can help. Something that's probably ties in with the statute that Reed was talking about, shifting gears, is preliminary hearings. I mean, from the defense perspective, preliminary hearings, my candid view, they're getting pretty close to worthless from the defense perspective, because so much can be admitted by reports, or just you play the CHC video and that's all you're required to do. But let me play devil's advocate a little bit and tell you some experiences that I've had. And I've done this several years, basically since I started doing defense work. Sometimes instead of doing a preliminary hearing or even a trial, I talk with the prosecutor and say, hey, we've got a victim. I realize it's tough to take them to court sometimes. It's a child victim, it can be awkward. And what I've done in lots of cases is we've agreed to go ahead and have a joint meeting. Have the child victim come in. We sit in a conference room rather than a courtroom. Typically we record it, and we just go through the things much more informally. And so the defense gets the perspective of being able to tell their client, look, I've met with the victim, and you're in trouble. She's real credible. On the other hand, I've had cases where the prosecution has walked out of the meeting and realized, yeah, we went through everything, but the victim didn't articulate all the elements of what I've charged, despite what was in the police report. So I encourage you to, be receptive to the idea. If you don't want to do it as a prelim, consider an informal meeting in a conference room where both sides are there. You're able to ask questions in an informal way that can clear up some of those ambiguities that sometimes are present in cases that, you may end up going to trial over something that could have been sorted out in a half-hour interview in a less formal setting. And I will say, every time that I have done one of those interviews, the case has resolved without going to trial. Usually, by the defendant taking the plea that was on the table, once I've been able to explain, it's a good offer, here's why I think the victim is credible. This theory that you had didn't pan out. And so be open to that idea. And I think the prosecutors that I've done this with, if you spoke to them, they would say, it's worked out well for them too. And I realize sometimes attorneys and prosecutors, defense attorneys, we're all different. Maybe some defense attorneys you wouldn't want to do that with, but I hope most defense attorneys would be willing to take the low-key approach that I take in exchange for the benefit of interviewing the victim in a setting that is going to get to the truth. And that's ultimately going to be in everybody's best interest, because if it hurts, if you go to trial and that victim comes on like gangbusters and your client has just been convicted of a first-degree felony when they could have pled to a second because they didn't think the victim was going to come through, well, that's a benefit for the defense, but it's also a benefit for the victim's family. If they were comfortable letting him plead to a second, now they've had to go to trial. So consider that as an alternative.
Yeah, let me take a second on that as well. I practiced as a defense attorney before the constitutional changes that allowed hearsay to be used at a preliminary hearing. In fact, I'm to blame for that, actually. I was the one that proposed that amendment and worked it through, that amendment to the Constitution. But before that, of course, victims always had to come to the preliminary hearing because you could not use a statement or even a recorded statement. And I would guess that in the vast majority of cases, those cases were resolved by exactly what Todd's indicated. We'd go to the preliminary hearing. We'd go into one of the side rooms with the prosecutor there and the victim, and I'd have a chance to talk to the victim. Then I'd have a chance to go back and talk to the defendant and exactly that issue. A lot of what a defense attorney does, and I assume that hasn't changed, is be a salesperson. You've got to sell the defendant on the fact that this is the best arrangement for him, and you've got to be able to establish with good reasoning why that's the case. And one of the very best ways to do that is to say, the main witness here is the victim. I've talked to that victim, and she's going to be, or he's going to be, an outstanding witness, and you need to think about that. And that has a huge impact on a defendant. So think about that a little bit. It is a little different format now. They don't have to come to a preliminary hearing typically, and after the Lopez case, probably seldom will you see them at a preliminary hearing. But that doesn't mean that you can't arrange some independent way for that victim to talk to the defense attorney. And you've got to take into account the victim's position. If it's a child victim, they have some special rights to not be mistreated in any type of discussion. You have to decide whether having them talk about it is going to re-traumatize them, and are you going to be able to avoid that completely if you don't let them talk to anyone? On the other hand, if you can resolve the case by an informal discussion, it's probably a whole lot better than having to go through a trial where that child or that rape victim has to go on the stand and be subject to pretty nasty cross-examination. And so if you're looking at comparing the trauma between the two, is less traumatic for the victim to talk in an informal way if it's likely to settle a case than it is to call them in as a witness and subject them to what always is going to happen, and that is a pretty tough cross-examination. So those are difficult decisions. Clearly, our research has shown that children, particularly, if they have to recount it time and time again, are going to suffer from that. That's why we established children's justice centers, because we didn't want those statements to have to be made to the law enforcement officer, and then to the doctor, and then to the DCFS worker, and then to the psychologist, and then to the prosecutor. We wanted one statement that could be reviewed by all of them, not have to then have them relive that very bad part of their life. So you want to make sure you don't instigate that. But again, a lot of times an informal discussion that's well controlled is a lot easier than having him come in and testify in a court hearing. So.
One of the other things that defense counsel appreciate, or at least I do, and I probably drive some of our prosecutors in Davis County nuts, and that's have as much specificity as you can in what you're conceding to in plea agreements, or what you're willing to recommend. We talked about being salesmen. I give my clients a speech that there's two tracks. We're always preparing for trial as a possibility, but the reality is 98% of cases are going to be resolved without a trial. So I'm constantly negotiating on your behalf. And it's helpful to be able to tell people, well, it's not just plead discharge and submit on a PSI report. It's helpful to be able to say, if it's a reduced charge, why that's a benefit for them. But even if it's not a reduced charge, especially these third-degree felonies, if, let's face it, few people are getting sent to prison where we haven't figured out in advance they're likely going to be sent to prison. So if odds are the defendant's going to get probation anyway, and under the statute, if they successfully complete probation, they can apply for the 402 motion. Why not go ahead and put that in the plea agreement? From the defense perspective, it gets me the tool to talk to my client and say, look, the prosecutors agreed that if you complete probation successfully, they'll complete probation successfully, pays your fines, fees, and restitution. We add that because some of those aren't terms of probation anymore, but so I've modified the language we use. They'll stipulate that you can have a 402 reduction. It's amazing how important that is to so many people to know that there's a light at the end of the tunnel that's faster than waiting for the expungement statute to kick in. And it makes a huge difference for all the obvious reasons: housing, employment, to not have that felony on their record permanently. And I think generally most of the prosecutors I work with, and I think most prosecutors hopefully are pretty generous with the one-level 402s. Where it gets a little more tricky is if somebody's got that second-degree felony, or they're charged with a first and there's an agreement to reduce it to a second, and we're asking for that second level that you have to have a prosecutor stipulation to. I just can't emphasize how important that is to defendants to have that light at the end of the tunnel, even for second-degree felonies. So you can be creative there. One thing that some of the prosecutors started getting worried about is AP&P was terminating people after 18 months. So if you agree to a double 402 after successful completion of probation, they could get rid of that second-degree felony in 18 months theoretically, and that didn't seem like a lot of time to some prosecutors. So sometimes what we've agreed to is, they get the one level when they successfully complete probation, and after another year or year and a half or whatever period you guys pick of being crime-free, they'll leave those a stipulation to the next level. So there's some ways you can write that 402 language that I think protects the interests that, as a defense counsel, I'm looking for, to give my client the light at the end of the tunnel, but prosecutors can still say in good conscience, well, I made sure this person stayed crime-free for a significant enough period of time that we feel comfortable doing the two levels.
And I've had the pleasure or displeasure, I don't know which it is, of working with legislature quite a lot in the last 10 years or so. And I've seen a huge trend there to allow expungements much more frequently. You've seen that in now allowing more drug cases to be expunged, even though they're felonies. You've seen it in JRI by reducing drug possession that used to be a felony to a misdemeanor. You've seen it last year when they passed the massive automatic expungement provision for most misdemeanors. I think you're going to see that in the future. I think that's kind of the trend of the legislature. So as you look at a case and look at what the current expungement provisions are, and maybe even anticipate what might happen in the future, those can be pretty good tools to use that 402 to get a plea and have some control over what happens, because they've got to at least behave themselves for the term of probation, and that sometimes can be quite a while. It can be a great tool, I think, to many of you in resolving cases.
And for similar reasons, recommendations regarding jail versus possibility of community service or home confinement. Again, the prosecutors I deal with, I'm sure would tell you, every time Todd says, well, won't you give me a no jail recommendation? They've already been, they've done 20 days. The matrix is likely going to be 30. The judge is going to order another 10 anyway. So let's put it in the plea agreement, because you kind of gauge what you think is going to happen. And that can be really helpful, especially, one of the other things I do when I talk to clients, one of the first questions after we talk about the cases, I ask them, what is it you're most concerned about? And most of them, if it's charged with a felony, it's, I don't want that felony on my record. I got to get it. I can't have a felony. But others, they maybe already have a felony conviction, or they don't really care. And their big concern is, I don't want to do any more jail time. So, when the defense attorneys are coming at you with sometimes what seem like contradictory requests for one case versus what they ask for another, most of the time it's driven by what their clients are asking for. And that's the other thing that I ask, be patient with us. Because just as you guys and men and women have problems sometimes dealing with victims or getting information from police, sometimes as defense attorneys, it's not even our client who's the problem. A lot of time, my biggest problem is not my client, it's the client's family, who want to play second fiddle to everything or second guess everything, and heaven help you if they've got somebody who's a civil attorney in the family who suddenly is an expert on criminal law. I see some heads nodding. Boy, so just understand that we have our pressures too, and we're all human here. And I personally believe that we're all working for similar goals, although obviously from different perspectives. I want the best outcome for my client as possible, but we also need to be realistic. And I understand, that prosecutors have a goal, that's to achieve justice. Most of the time, hopefully those things are pretty close to each other. Sometimes they're not, but I think most of the time there's a lot of common ground between those two goals.
Yeah, sometimes we forget that and kind of forget who our clients are. We don't necessarily represent anyone other than the people in the state. And so our job as prosecutors is to try to find the thing that makes the most sense for everyone. And maybe that even includes the defendant. What can we do to try to make sure that this defendant isn't going to be back in front of us in another 6 months? And if there are ways to do that and get him out of the system or her out of the system and not have him come back, that's positive. And then a lot of times you're making some huge decisions that affect people's lives, and you've got to look at that feeling within yourself of what is the just way to handle it. I remember years ago as county attorney having a case where we had a group of kids, they were seniors in high school, turned out to be 217 and 218, had decided that it was pretty cool to make little bombs out of 2-liter bottles and dry ice. If you put a little dry ice in and a little water in, put the cap on, it gives you a pretty good bang. Then they decided that instead of toilet papering one of their friends' houses, they'd put this little dry ice bomb in the mailbox out in front of the house, one of those ones on a stick and just a simple metal mailbox. So they stuck it in the mailbox, and then they went and hid down the street. Doesn't go off right away. I don't know if you've ever done one of those. They make a big bang. It takes a little while, and so they watched, and unfortunately during the time that it was waiting to go off, one of the neighbors was walking his dog along the sidewalk, and when that little bomb blew up that mailbox, he was right next to it, and it put a big piece of mailbox in his leg. It hurt him pretty bad. So here you go. They were arrested by the police. When they found out who it was, they were charged, or they were booked or sent into detention on a first-degree felony. And that comes in for review. Well, here you've got a group of kids that are teenagers in high school. All of them were pretty good students. They all actually were pretty good kids. They were very involved in the community, very involved in athletics. What do you do with it? What do you do with it? I decided the best way to handle that would be first to talk to the victim. So I went up to the hospital and sat down with the victim, explained to him what had happened and who these kids were. His comment was, well, I don't want to do anything that will ruin their life. I'm hurt, and I don't feel good about that, but I don't want to ruin their life. My next trip was the arresting police officer, who put a fair amount of effort in trying to identify these kids, and talked to him a little bit about it, and his view was kind of the same thing. So we end up with a charge that is nothing like a first-degree felony, and they ended up to be pretty successful kids. So I think you got to look at that as well. What can you do to try to be fair to everybody involved and try to get the best result, which is never to have these things happen again and not create a criminal out of somebody that really isn't a criminal.
So is one of those kids the guy who teaches chemistry at the U now?
Might be.
You never know how people are going to end up. So I can totally concur with Reed to try to work things that are take into account everything. And that actually ties into what I list as kind of a pet peeve that I got from defense attorneys. And that is the instances where we hear the victim is rabid and wants everything nailed down and the person to get the most severe sanction possible, and they're real fired up. We get an earful on those cases, but then the case where the victim is like, it's not that big a deal, let them have a misdemeanor, I don't want them to do jail. Some defenders complain that they see a double standard, that some prosecutors are reluctant to give weight to what the victim wants if the victim's advocating leniency versus advocating harshness. So I just throw that out there to be sensitive on both sides of the issue.
Yeah, and my point here would be make sure as a prosecutor before you work out a plea, you've talked to the victim about it and let them know what's going to happen, and also the investigating police officer. No better way to make an enemy of your investigating officer if you do something that reduces his case and haven't talked to him or her about it. So make sure you take those steps.
Just as long as you agree with what we request at the bottom, the bottom of the whole thing. A couple of obvious ones: slow or no reply to emails or calls. I understand that can go both ways, but defenders, again, we've got our own set of pressures, usually coming from our clients or their family members, and it's hard to say, well, I've reached out to the prosecutor, I'm waiting to hear back, and you tell that 2 or 3 times, and 3 weeks go by and you're still waiting for an answer, and that has happened to me, very rarely, but it has happened, and boy, that's pretty frustrating. And I think especially in this day of COVID-19, where we're all relying more on phone calls and emails as opposed to popping into each other's offices and sitting across the table, it's real important for both sides to be sensitive, to give those responses in a timely manner, because even if it's, hey, I need more time, then at least you can tell your client they're still working on it. This next one I'm sure is going to be kind of controversial, but I'll raise it anyway. And that is, a number of defenders noted that it's kind of frustrating that there'll be cases where sometimes it's the victim or a witness is the only evidence. There's no physical evidence, there's no videotape, there's no independent witness. And so it's kind of, one person says and the client denies. And, we may have a client take a polygraph or an eye detect exam, and they'll pass it with flying colors. You get excited, you go to the prosecutor and say, hey, I had my guy polygraphed, and he's off the charts, truthful, no, not even a hint of deception, and have the prosecutor, big deal. Well, understand from our perspective, law enforcement uses it all the time for a tool. Specialty courts use them, AP&P use them, and somehow they're valid there. We understand they're not admissible at trial, but at the very least, if you've got one of those cases where your case boils down to one person's testimony against the defendant's denial, it at least give us, enough comfort in saying that, you'll take another look, you'll rethink things. Maybe you'll talk to the victim again and see if, maybe they misunderstood something, or, the officer who wrote the report didn't get it quite right. So I think when, those things come up, not saying necessarily, just give us a dismissal right off the bat, but at least, give a little credence. If it's credible enough that they use it to test parolees and probationers and people that participate in drug court, it ought to at least be worth saying you'll give the case a second look at.
Yeah, I think that, in my view, would be certainly a case-by-case basis. You look at what's going on and decide if that's appropriate. When I said you had to be a salesperson if you're a defense attorney, you also have to be a salesperson somewhat as a prosecutor with the police and with your victims. Now, you don't have to have consent from either one of them to work out a deal, but it sure goes a lot easier if you do have that. So if you can use this as one of the tools to help you get where you want to go, I think it's a very positive thing. And kind of the next thing that I heard a lot of, it's not as prevalent as it used to be because of some changes in the law a couple of years ago, but consideration of collateral consequences, mostly immigration. The change a couple of years ago that made Class A misdemeanors 364 days as opposed to 365. It's a huge difference for a lot of immigration consequences. But it always kind of strikes me as a little ironic that, we'll get to sentencing and there's all the talk about, don't put mom or dad in jail because they've got all these kids and kids aren't going to have mom and dad there as a breadwinner or after school or whatever. Or whatever the case may be, the person who's a real estate agent that'll lose their license if they get a certain conviction, or a nurse. We spend a lot of time talking about that, and oftentimes feel like prosecutors are pretty receptive, but sometimes when it comes to an immigration issue, it's a little reluctant because they know by definition the person's not a U.S. citizen. Well, the case law actually makes pretty clear, you're right, they're not U.S. citizens, so their rights are a bit lessened, but if you read the Supreme Court cases carefully, it also makes clear that, this is a role that prosecutors play. You are the voice of the community in these things. And sometimes I think the voice of the community weighs in favor of, okay, this person's been here long term. Yes, they committed an offense, but it's not the crime of the century. Is there a way to do something that'll help them avoid immigration consequences that could result oftentimes in them
if they get removed, they may have U.S. citizen children here who are underage and can't do anything. You know, the old anchor baby thing that we've heard about that's pretty inflammatory doesn't apply to them. Or their wife or husband is a U.S. citizen, but they don't have the number of years in to make it through the fiance or marriage process in time. So it always strikes me a little ironic that, you know, when somebody's removed from the country, one of two things happen. Either they're separated, well, three, I guess. Either they're separated from the family total and they stay in the country they're deported to, or number two option, they come back illegally and they're living in the shadows, or third, although I've never had this happen, the family relocates to the foreign country. Typically, families that have U.S. citizen children aren't eager to go to, you know, foreign countries that aren't as desirable as the U.S. So I encourage you, you know, be a little bit creative there. I can recall a case I had years ago in Salt Lake, and this is a real anomaly, and I recognize you've got to take it case by case. If somebody's slinging drugs all over the place and they're a major drug dealer, you know, I get you're not going to be sympathetic to their concern about being removed. We don't want them as part of the community. I'm not talking about a specific case now, so I can say I don't want them as part of the community either. But oddly enough, I had a case not long after I started doing defense work where a guy, he was a runner for a major drug dealer and was here as a lawful permanent resident, but easily could have been subject to removal. But we worked out something pretty creative with the prosecutor. He said, well, you know, he's cooperating. The strike force likes him. He's actually kind of got into this because of money problems, and he got addicted and was doing it. Kind of the story we all hear. Somebody got addicted, and next thing they know, the way they get their drugs is agree to the dealer, okay, I'll deliver for you. That's kind of what happened with this guy. So he cooperated, and what we did, even though he was facing a second-degree felony, we actually agreed to meet. We did a videotaped full confession of this guy where he laid out everything he did, and we had a gentleman's agreement that the prosecutor would hold on to that. He gave him a plea in abeyance, and if he did everything required in the plea in abeyance, the videotape never made its way beyond his desk. But if there was a violation of plea in abeyance, had the ready-made case. Full confession with attorney there, and he had a second-degree felony hanging over his head. He successfully completed probation, eventually became a U.S. citizen, and opened his own business. So once in a while, you know, be open to something creative. Now that's probably my most extreme example, but it's one I like to tell about because it was one where, you know, we got really creative. Where, again, talking with the police, they were on board with the idea. They felt the guy was getting ensnared, but there was this discomfort of, you know, boy, do you really give a guy who, you know, made numerous drug deliveries, do you cut him all the way down to a Class B to avoid potential immigration consequences?
Good. So we've got about 10 minutes left. I just need to take a few minutes, and I just wanted to, and by the way, thank you, Todd, for those. I think those are excellent thoughts. Some of them you may say, well, okay, I'd expect that from a defense attorney. But I think a lot of it is really good information, and I think you need to look at it from the fact that we're all trying to get to a common goal of doing the right thing and getting justice for everyone. So let me just take a few minutes, though, at the end of the presentation. Thanks. At the end of the presentation, just talk a little bit about your role, in my mind, as a public prosecutor. I think it's a different role than a defense attorney has. They represent an individual client, and their job is to do the very best they can to represent that client within ethical guidelines. Your job, though, is to do your best job of representing the people of the state of Utah and doing what's best for the people. And I think that goes beyond the individual cases that you're working on. It's important, I think, to make sure you take that into account in deciding how you're going to prosecute an individual case. But I think it's also important for you to look at the broader angles of all of these things and see what you can do to improve the entire criminal justice system. I started out by talking about my experience on a domestic violence case. That since that time, I've learned a whole lot about domestic violence. When I started at the Attorney General's office, we wanted to have a theme for the office, and that became the theme. And we tried to change the laws and had some success on this mandatory arrest concept. With Chris Knowlton's help, we were able to establish that domestic violence in front of a child should be a punishable offense. But a lot of times you talk to an audience that just glazed over when you talked about domestic violence. That doesn't happen to us, doesn't happen in our neighborhood. So we created, through the AG's office, a group of what we call safe at home teams all over the state. And we created a video that the Attorney General was in that talked about and demonstrated what the impact of domestic violence is. And we showed that video and gave a presentation in literally thousands of venues all over the state. Every service club we could get into, church groups, voting groups. We ended up going to city councils and county commissions all over the state and doing that presentation. And what I felt that did is later on, when we had to go back to the legislature and ask for more changes, a lot of them already knew about the things we were talking about. You'll find that many legislators start out as city councilmen. They'd heard that discussion, and they were very readily available and accessible to talk about it, and were willing to make changes in the law that made a huge impact on the way we deal with domestic violence. Hopefully we don't have the Margaret Madison case, which is the one that I had defended, happen again. Hopefully we get a hold of it before and don't let it get to the point where somebody kills their live-in partner. Just a couple of other stories that kind of illustrate, I think, the same thing. While I was county attorney, I had two cases that had a real impact on me in another way. We had one that was a serial rape case, and at the time I started as county attorney, we'd had maybe 35 rapes in the last 6 months, all in the central Ogden area, all against people in their home, young girls that were single, either divorced or had never been married but had small children. And this guy would break into their house. He threatened to hurt their children if they didn't comply, and then he'd sexually assault them. And then he'd tell them that he had connections with the police department, and if they went to the police, he'd know about it, and he'd come back and kill them. Many of them didn't come to the police until it all came to light. But eventually we got a break, and we got a witness that was able to identify him from having had him in her house. And we prosecuted the case. It's a long story. It took probably 3 weeks to prosecute that case. Eventually we got a conviction, and he went to prison on a minimum mandatory term. In fact, he may still be there. That was 30 years ago. After the case, I did what I often did. I asked the victim of the case that we prosecuted to come in and talk to me about how she felt about the case. And her response, I thought, was remarkable. She said, well, I appreciate the prosecution. I appreciate that he was convicted. I know that he's now in a place that he can't hurt me. But do you know what we all went through, speaking of herself and the other many women that had been assaulted by this guy, during the case itself? And I said, well, no, I don't. What happened? Well, apparently he was arrested, booked into jail. They set bail at something like $100,000. But he was a well-connected guy, was able to post the bail, and so for the full time that we prepared for trial and went through the trial, he was out of court, or he was out of jail. And all of those women had been threatened that he would come back if they told their story, and he would kill them and he'd kill their kids, and they were petrified. Most of them had left their apartments and moved into other locations and had tried to avoid having him be able to find them. All because he was allowed to be free during the time that he awaited trial. Another case about the same time involved a little girl that was abused up at the Lindquist Plaza, which is we call it the duck pond at Weber State University. He was a foreign student from Iran. We charged him with sexual assault of a child. He was booked in jail. I argued to the trial judge that he ought to remain in jail because he was from Iran and he'd go back to Iran. He was from a very wealthy family. We lost that. The judge set bail. I then appealed that all the way to the Supreme Court, argued it at the Supreme Court level. They said, we don't have the power to deny bail because you think he's going to run. So those two cases generated another change in the Constitution. We were able to get a legislator to sponsor it in the legislature and then take it to a vote of the people that allowed us to, on a case-by-case basis, a judge to deny bail because of a person being a danger to the community or because they're likely to leave and abscond and not appear for trial. Now you have to make a good showing and able to establish that, but that came about because of cases that I'd handled. You're going to handle cases like that, and you're going to see things that need to be changed. Take the opportunity to make the effort to try to make those changes. We mentioned the constitutional amendment that is involved in that Lopez case. That actually arose from cases that we had in Ogden. You may have heard of the John Albert Taylor case, which is a fellow who broke into a little girl's house. She was 11, and he sexually abused her, and then he used the telephone cord and strangled her and killed her. We prosecuted him successfully after a long time. He went to prison and was actually the last person executed by firing squad in the country. After that case, I sat down with the mother of that deceased little girl, Sharon King, and asked her how she felt about the prosecution. And she said, you know, it was one of the worst times of my life. I was a witness, and therefore everyone felt I shouldn't be told anything that was going on because it might pollute my testimony. So I got very little information about the case during the time that it was pending. When the trial was going on, I was excluded from the trial. I was brought in to testify, and then I was kicked out. The defendant sat through the whole trial and listened to everything, but I couldn't do that. Well, that seemed like a gross injustice. And so that was the impetus for us to then look at some of the other victims' rights and change the Constitution to recognize the rights of victims. And then we passed extensive legislation at the same time that provided rights for victims of crime. All coming because of a case that we prosecuted. Kind of the same thing with children's justice centers. I remember one day I was called, the county attorney's office was at the top of the county building and the police department was at the bottom. I was called and they said they had a little girl that had been reportedly abused, and they were trying to interview her and she wouldn't talk. They wanted me to come down and talk to her for a minute. So I went down to the police station and I walked into the detective department. It was a room maybe 2/3 the size of this room. There must have been 15 detectives with desks in that room, no dividing walls at all, and they were all busy doing something. In the desk that this little girl was seated in front of, there were two adjoining desks. One was a detective interviewing a victim who was in tears. I think it was an assault victim. On the other side, he was interviewing a defendant. And here this little 5-year-old girl was there in the chair with her mother and scared to death and wouldn't say a thing. Well, it just occurred to me and to those detectives that were working on it that something had to change. That wasn't a way to interview a child. So we initially set up a special room in the county attorney's office that we decorated to be child-friendly, and those were conducted there. Later on, that morphed into a separate facility that we called a Children's Justice Center. Initially, we did that in an office building and found that wasn't good, so we actually bought a house, remodeled it, and turned it into a Children's Justice Center. And now we're on our third renovation of that. We're trying to build a new one for the third time to house the caseload that we have. But the idea was, let's find a better way to deal with those kids. Let's not traumatize them again, maybe even more during the investigation than they were traumatized in the event itself. So let's just interview them once if we can and use that tape to meet everybody's needs. Let's do it in a place that they don't feel intimidated. Let's make sure that we have interviewers that are forensically trained and know how to deal with kids, not some rough, tough police officer that's going to scare the daylights out of the little kid. So all of those, and let's give them a medical exam. Let's give them a psychological exam. Let's make sure we follow up on anything that we find, not only for forensic reasons, but also if they have things that need to be treated medically or psychologically, let's make sure we deal with those. All of those things are now done in a Children's Justice Center, and all of that happened because of individual cases that myself and others were involved in that really called for that type of change. So keep that in mind. Your role as a public attorney is much more than just prosecuting individual cases in my mind. Your role is to make sure that we do the best job we can of creating a justice system that's fair to all. And if you do that, and if you work at it, I think when you end your career, and hopefully my wife tells me I'm at the end of my career, I don't know. But when you're done with your career and want to look back at the things that you've done, I think those are the things that you're going to focus on, probably more than the individual cases that you prosecuted. So thank you for your attention and enjoy your work.
Thank you, Reed and Todd. We appreciate you guys coming in and finishing up this portion of Fall Conference. Just a couple of administrative things. The templates that Kiza talked about yesterday, she has emailed those to me, and they have been uploaded into the Fall Conference portion, or the web page. You just need to click on their presentation. And so Ron put all of those templates into a zip file that you can download. Nick Bricker, the documents that he was referring to this morning, He said that he would email those to me on Monday when he's back in the office, and we will get them uploaded. On your course evaluation, if you have now just started filling it out, our training committee really appreciates any suggestions that you have for future topics. We look at those, we take those very seriously, so please include those. A new thing that we're including, let me just remind you, is, I think it's the very first question we ask, is what are the 3 things that you learned from this conference that you're going to incorporate? That's important to us as UPC because we now have to report to the legislature metrics and different things. And so this is one of the things that we have to report back to the legislature. So if you'll include that, we would appreciate it. And then just to complete the circle, what Reed was talking about, let me harken back to what Jeff Buhlen and Ryan Robinson mentioned yesterday in terms of SWAP. If you notice changes that need to be made, if you've got suggestions, please funnel them up to SWAP so that we can make those changes like Reed was talking about. Thank you for those that are signing off and are not going to stay on with us through the juvenile justice practice after 9 this afternoon. You guys have a great day, and we'll see you at the next conference.